U.S. Supreme Court weighs Trump's move to end birthright citizenship. The U.S. Supreme Court heard arguments Thursday in a case that challenges a past decision of U.S. President Donald Trump in the form of an executive order that closes the door to birthright citizenship, a constitutional principle that for many years automatically made all persons born in the United States its citizens. It is the moment the Supreme Court reviewed Trump's executive order of January 20th, which was the first of its kind in the history of the nation and which sets out to take citizenship away automatically from children born to undocumented immigrants and certain foreign visitors in the United States. Two legal questions, one historic debate. The court has given no specific deadlines for the release of its decision, though the justices discussed at length and were particularly keen on two legal issues. Does a federal judge have the right to stop, with a nationwide injunction, the enforcement of a president's executive order? Does Trump's executive order constitute a breach of the 14th Amendment, in particular the Equal Protection Clause? People demonstrated, and immigration representatives brought their concerns directly to the street. We have gathered here at the Supreme Court today because one of the foundational promises of this country is in jeopardy, commented Ama Frimpong, legal director at the immigrant rights group CASA. All persons born in the U.S. are citizens of the U.S., a foundational clause under review. At the Supreme Court, Acting Solicitor General John Sauer presented Trump's arguments that the 14th Amendment passed in 1868 has been misinterpreted and that the correct interpretation is that only the formerly enslaved people's children deserve citizenship. He also emphasized that the amendment never covered children born to illegal immigrants and people with temporary visas. Trump took to the new media outlet on Truth Social preceding the court date to affirm his previous statement and explain that citizenship by birth has become a loophole in immigration and has affected the U.S. to be considered a stupid place for birth tourism. Additionally, Sauer argued that decisions of the three federal district court judges who had enforced a temporary injunction should have been limited in their applicability to the plaintiffs and their respective cases and not taken as precedents in the entire country. Judges comment on the case. Quite a few of the judges disagreed with the government's positions. Justice Sonia Sotomayor stated that the executive order seemed to violate 4 previous judgments from the Supreme Court, one of them being the historical case of 1898 United States Wong Kim Ark, which declared that the 14th Amendment ensures that all persons born in the United States, excepting those not subject to the jurisdiction of the country, are citizens no matter their parents' immigration standing. Justice Elena Kagan brought up the issue of practicality, inquiring, is it necessary for every single one of the persons on whom the executive order has any impact to file their own suit? Even more negative was Justice Ketanji Brown Jackson, who gave a severe warning that a restricted judicial system could become a catch-me-if-you-can regime, so that people would be left with no other choice but to take the government to court in person for them to be sure of their rights. The likely impact of a broken-up judgment. Several judges explored the idea of deciding only one aspect of the injunction to ban the use of nationwide injunctions and leaving the entire constitutional question unaddressed. This could create a legal quagmire, causing confusion and uncertainty. Commentators point out the possibility of a situation where some states will remain unaffected by the presidential directive. At the same time, the rest will stay subject to it, with each future challenge standing or falling on its own until the courts resolve the laws. If the laws of each state are not clear-cut in this case, it may cause misunderstandings as to who is actually entitled to citizenship and dependent on the nation of birth of a child, and whether a state has challenged the executive order. The question of consequence. According to the legal expert's opinion, a court decision that empowers the federal judiciary in different states to issue questionable injunctions could mean that the U.S. has to adjust a lot of constitutional lawsuits sue in another way. However, the existence of the 14th Amendment was even more crucial as the priority question of whether the president could, on his own, change the fundamental understanding of the 14th Amendment. Privy here to the domain of only constitutional scholars and courts by historicity, the judgment in this particular lawsuit will not simply say whether it will be possible to have the president's decision generously interpreted, limit the authority of federal courts, or strip the birthright citizenship crop of American national pride. But it could also mean the very opposite, something, and that is a change of the position of different institutions and perhaps the existence of the power of deciding the matter in the hands of the people in the future.